Hey there, I'm estate planning attorney Paul Rabelais, and in this video we're going to talk about when it's necessary to restate your revocable living trust or maybe even redo your will. So to get right to it, you may need to restate your living trust if a beneficiary dies, or if you get divorced, or if you want to appoint someone new to be the trustee to handle things when you pass away. You may need to restate your trust for tax purposes, especially if you're married and your trust is older, say pre-2010, when for many couples, avoiding the federal estate tax was more important than getting the double step up in basis. Or, of course, you'll need to restate your trust when you've changed your mind about how you want your estate distributed. So, hey, I'm Paul Rabelais. I own an estate planning law firm based in Louisiana, but trusted by families nationwide. We've built a trusted network of attorneys across the country, so you can get the same expert level estate planning no matter where you live, with me personally guiding your plan. This approach ensures clients, regardless of their location, get well-rounded legal services tailored to their specific needs. Okay, so let's look a little closer at each item of restating your trust. First, let's talk about the difference between a restatement and an amendment. So many people create a revocable living trust during their lifetime and they realize they need to change something. And what I'm not talking about is, let's say you acquire a new asset, maybe you buy a new home, and you don't need to change your trust. You just need to acquire your home in the name of your trust, or maybe you set up a new brokerage account and you don't need to restate or amend your trust. You need to simply title that brokerage account in the name of the trust. But we're talking about when your trust needs to be amended or restated. Sometimes if there's, I'll use the word simple, there's a simple change that needs to be made to someone's revocable living trust. Like maybe someone wants to change the second successor trustee to handle things if they pass away. Maybe they'll make that change by doing an amendment. So they work with the attorney and they get a document prepared, and the document says, I created this trust back on this date in this year, and I'm amending paragraph 2.3 now to say this. That's an amendment to your trust. So when you pass away, people have to look at your original trust and they have to look at your amendment or any other subsequent amendments, kind of piece it all together to figure out what you wanted. But most people these days, when they make changes, they don't do an amendment, they do a restatement. So you simply keep your trust name and you simply restate the terms of the trust. So let me talk about when restatements seem appropriate. Obviously, if you get divorced, if you're married, you're likely naming your spouse to have for a number of appointments and bequests in your trust. And if you get divorced, you're probably going to want to take all of that out. Great opportunity to restate your trust. If a beneficiary passes away and your trust no longer reflects the people in your life, that's a red flag. Although sometimes a beneficiary does pass away and we don't need to restate your trust. Sometimes people say, when I pass away, I want all of my trust assets to go to my descendants per serpes. Let's say they have 3 children. One of the children passes away after the person set up their trust, but the beneficiary who passed away has children, and the person who set up their living trust wants the child's share, who is now deceased, to go to the child's children. Maybe it's not necessary that that trust be restated. Have to look at some of those contingency provisions in your trust. But getting divorced, the death of a beneficiary, certainly a good opportunity to take a good hard look at what you did, and in many cases you'll need to restate your trust. Mentioned it early, designating someone else to be the trustee of your trust when you pass away. Sometimes when people create their trust, they figure out and they ask a person, hey, will you be the trustee when I pass away to handle the distribution of my trust assets? They say, sure. Years go by and you rethink that decision. You're like, maybe this person that I named originally is not the best person to handle my trust when I pass away. I'd like to change all of that. So perhaps restating your trust is the best way to do that. Now, here's a tricky one: dispose or acquire a major asset. So if you owned a business and if in your living trust you made specific provisions about your business, maybe you said, I own ABC LLC, and when I pass away, I want 70% of that asset to go to person 2, 20% of that asset to go to person 6, and 10% of that asset to go to whoever. But then you sell your business after you've made all those provisions. Well, likely now that you don't have the business anymore, you've got a pile of cash, and depending upon how you set up your trust, probably a great opportunity to at least revisit or probably restate the terms of your trust. Now, I will say sometimes a person will own a business and their trust says, when I pass away, I leave things to my children equally. They sell the business, they get millions of dollars, but it doesn't change the distribution schedule when they pass away. Whatever they have when they pass away, they want it to go to the 3 children equally. So just because they sold their business, they may not need to restate their trust. All right, sometimes tax law warrants restating a trust. And what I'm about to go over with you is fairly significant, can't be done with an amendment, would need to be done with a restatement. So for example, many married people before 2010, they left their estate, the married person left their estate to a credit shelter trust because they didn't want their estate to get lumped into their surviving spouse's estate because there were real limitations on the estate tax exemptions and how much of an exemption each spouse could use. A lot of that has gone away with portability that got enacted in 2011, made permanent in 2013, and now with the much larger estate tax exemption, 13.99 million for deaths in 2025. With the combination of what we have now, married couples can really shield $28 million from the federal estate tax. So the emphasis on saving tax is not so much saving estate tax, because most married couples don't meet those estate tax exemption amounts. The emphasis now on saving tax from an estate is making sure couples do what they need to do so the family gets what I call the double step up in basis. Again, pre-2010, pre-2010, the thinking was a married person doesn't want to lump anything into the estate of the surviving spouse, so they leave their estate to a credit shelter trust. Now married couples are thinking to themselves, I think I do want to include everything that I own into my surviving spouse's estate, because if I do that and all those assets get included in my surviving spouse's estate, then years later when my surviving spouse dies, all those assets will get another step up in basis, which can save significant capital gains tax when the kids ultimately sell the assets after the surviving spouse passes away. All right, I've had the conversation with many people about, do they restate their trust if they move to another state? Well, I'll tell you, most trusts are not invalid just because you moved to another state. So the idea of whether you should restate things just because you move to another state, I would say we start with it's not always required. But maybe if the state you're moving to or the state you're moving from has some really particular estate taxes at the state level, maybe an adjustment to your trust can be necessary to minimize or avoid those state level estate taxes. All right, another scenario where it's probably a pretty good idea to restate your trust is if you've made a bunch of amendments to your trust. I've seen people come to me, they bring their original trust that they did 20 years earlier, and then they bring me Amendment 1 that they did 2 or 3 years after that, and then Amendment 2 a couple of years later, Amendment 3, Amendment 4, Amendment 5, Amendment 6. So I've got this original trust, and then I've got multiple amendments that were done over the years, and each one refers back to others. You'll be doing your survivors a big favor if you just really scrap all of that original trust and amendments and all those subsequent amendments and simply do a brand new restatement. One document governs everything. Restatement may be appropriate there. But then probably the most common reason why you need to restate your trust is you just change your mind about the distribution schedule and who you want to inherit your assets. All right, let me touch on whether you should do a restatement of a trust or whether you should do a new trust. So I've had people come to me in the past, they said, Paul, I did this trust 15 years ago. I say, what's titled in the name of that trust? They're like, absolutely nothing. We didn't fund it. We just created the trust and we didn't do anything with it after we created it. Well, since those people don't have any assets titled in the name of their trust, we can just kind of scrap that one. It doesn't own anything, and then just create a new trust and then make sure that new trust gets funded. But what if that old trust does have some assets that are titled in the name of their trust? Maybe a business, maybe some rental property, maybe a brokerage account, maybe a home. Well, instead of doing a whole new trust and removing the assets from the old trust and having to put them in the new trust, we simply just do a restatement. We keep the name of the original trust the same. That way, all of those assets that are already titled in the name of that trust can stay titled that way. But then we do that restatement, just restating all the terms of that trust to make it current. So that's the restatement versus new trust scenario. And then, by the way, I'm referring to trusts here because I think most people in America who want to make things easy for their family, instead of doing it the traditional way of leaving assets in their name and providing for their survivors through their last will and testament. See, when you do that and you leave assets in your name, then when you die, your assets are frozen. There's a probate necessary. Even if you had a will, there's a probate necessary because there were assets in your name when you died. And so courts and lawyers and judges have to get involved in order to get those assets transferred to the appropriate heirs that are listed in your will. Most people don't go that route. They want to avoid that court and attorney involved probate process. So they set up their revocable living trust. The key there is things that are already titled in the name of your trust when you pass away. They don't go through that court and attorney and judge involved probate proceedings. So it really simplifies the settling of your estate when you pass away. But many people, however, nonetheless, they have their will plan, and that's what they chose to do for whatever reason, and they left their assets in their name, and they used their will to provide for who's going to be the executor when they die, who's going to inherit, what are they going to inherit. So all those reasons where someone would restate their trust, well, those same reasons would apply as to when someone would redo their will. Okay, so if you're not sure whether it's time to update your trust, whether it's an amendment or a restatement or an all-new trust, or whether it's time to redo your will, or in some cases do an amendment or something called a codicil to your will, probably appropriate to talk to an estate planning attorney who can review your documents and review your estate planning objectives with you and help you decide. See you next time.